Quick setup before we dive in. This is a sentencing hearing, not a trial. The judge has already heard the evidence, and now we're watching how the law, discretion, and emotion collide. Pay attention to how much weight the judge gives a process versus impact. That balance is going to matter a lot by the end.
That's position on this case.
Judge, I'll only note that if you look at on the second page, it's kind of close to the bottom in the paragraph where it says, the court also noted that it's not essential that the weapon used during the charged felony is a firearm in order for reclassification under section 775.087 subsection 1.
This objection right here is about sentence enhancement, specifically whether the firearm automatically bumps the charge to a higher felony. Defense is preserving this for appeal, which is lawyer speak for, we're losing this now, but we want a higher court to look at it later. Smart move, even if it doesn't change today's outcome.
But in this case specifically, it's the firearm that requires it to be enhanced to a first-degree felony, so that's why I wanted to make that objection for the record.
All right. I'll overrule the objection based on the Lewis case.
Yes, sir. And then I believe there was a PSI done in this case. I think the court
Yes,
has
ma'am.
a copy of it. I'm not sure if the court has looked at it and relied on it. The only objection I wanted to make to the PSI, there were a few letters that were included by the probation officer that were typed. They were not authenticated, not sworn. So I would just ask the court to disregard those letters.
Okay. I would just, it's in the PSI. Whatever's in the PSI I've looked at. I don't generally look at letters and other things that are in PSI, and I didn't put any weight on them in this case. The reason I do that is because
this is a really important sentencing philosophy moment. The judge is saying, I don't reward defendants for having better support systems. That sounds harsh, but legally, it's about consistency. Question for you. Should sentencing be strictly uniform, or should personal circumstances like family support actually matter?
I think I've pretty consistently over the last 17 years sentenced the same, pretty much on the nature of the offense, whatever the person's prior record might be, and whatever I think they may do in the future.
Here's where it gets legally nuanced. PTSD can be a valid basis for a downward departure, but only if it clearly affects behavior in a legally relevant way. The judge accepts the diagnosis, but watch how carefully he separates mental health from legal responsibility.
I think that's pretty much how I do it. If I start looking at letters from friends, well, the problem is that I may give a break to someone because they have friends, and someone who doesn't have friends doesn't get that break. So I simply never do that. I sentence everyone pretty much the same, I think, over that period of time. I do find that the defense has produced evidence that she would qualify for departure because she has for a mental disorder. I think they found. I find they've proven she has PTSD, which is a recognized mental disorder, and is unrelated to substance abuse or addiction, and that she is amenable to treatment. So I do find she would qualify for that departure. On your second one, the capacity of the defendant to appreciate the criminal nature of the conduct.
This is a turning point. Even when legal grounds for leniency exist, judges can still say no if the aggravating factors outweigh the mitigation. Translation: yes, I could reduce the sentence, but I'm choosing not to. This is pure judicial discretion, and it's often where cases become most controversial.
I don't find there was sufficient evidence to prove that departure. There was no indication that she ever did not understand what she was doing, or that shooting at a person would be against the law, or that she couldn't conform with the law in any way. As a matter of fact, she seemed to be, prior to the shooting, calling the police. So it didn't appear to be any situation where her capacity was impaired in any way. I don't find there's evidence that the victim was the initiator, willing participant, aggressor, or provoker of the incident. Otherwise, although she was knocking loudly in this case, there was no real attempt to get in the residence. She kept asking her to come outside. So I don't find that that departure ground has been met. Despite the existence of one legitimate departure reason, even if she did qualify for the other two departure reasons, I would not depart in this case because I find that the aggravated nature of this case and this offense and the harm inflicted outweighs the mitigation or the departure when I weigh the totality of the whole case. So I find that the seriousness of the offense outweighs any legal departures that could be applied in this case. I'm primarily looking at the harm inflicted upon not only the victim, who of course lost her life, but her family. She has 4 children, all of whom were present during the offense or somewhere in the general vicinity, or at least home. It certainly will have a traumatic impact on their lives for the rest of their lives. They'll live their whole lives without their mother, which I think is a very significant harm inflicted upon them by Ms. Lawrence. When I look at the nature of the offense, I find that the shooting was completely unnecessary in this case. Ms. Lawrence was behind the door was locked. She had already called law enforcement. They were en route. She knew they were en route. She was in a relatively safe position. For some reason, she went into her room and found a gun. She could have stayed in the room and put another locked door between her.
Listen closely to the language here. Anger versus fear. That distinction is everything. Self-defense cases live and die on it. Once the judge frames the shooting as driven by anger, not imminent danger, the sentencing math changes completely. Do you agree with that assessment based on what you've heard?
And Miss Owens, but she came back out, put herself in front of the door, and at the time she fired the gun through the door, she was safe. Miss Owens was simply, although she was clearly banging loudly and was probably very angry over the whole situation, it appears to be she was mostly demanding that Miss Lawrence come outside, which would indicate she had no indication of coming inside the house. So when Miss Lawrence fired the gun through the door, she did so knowing a person was directly on the other side of the door. And she knew that person wasn't a burglar, she wasn't a robber, she wasn't a rapist. She knew she was probably upset about the interaction with the kids, but she had arguments with her before, and no real harm came other than, I guess, a sign was thrown at her, a paper sign. And that's when she decided to shoot. I find that the shooting, when I listened to every aspect of the trial and every aspect of sentencing here, it's the facts don't rise to a murder charge, but they are very aggravated manslaughter. Because this case, the shooting was based, I find, more on anger than fear. And I think that's pretty well established in this case. So when I weigh it out, and believe me, I find that she's a victim of child sex abuse, was a significant mitigating factor, and she has no criminal record, which is also a significant factor. However, we also have a tremendous harm inflicted upon this family and the victim's family. So what I'm going to do in this case is order she be adjudicated guilty of manslaughter with a firearm and order to serve 25 years in the Department of Corrections with credit for 538 days. It's $100 cost of prosecution, $100 fine, court cost. Good luck to you, ma'am. You have 30 days to appeal. Is the defense requesting the appointment of public defender for purposes of appeal?
Yes, sir. Just a few more things I want to put on the record.
Yes,
there was
ma'am.
never an offer by the state. The state had asked us to make any reasonable offers. Ms. Lawrence chose not to do that, just for the record.
Okay.
We also did not file a stand your ground motion for strategic purposes. That was also discussed with Ms. Lawrence as well. Just wanted to put that on the record. That's it, Judge.
I'll appoint the public defender for purposes of appeal. Good luck to you, man.
Thank you, Judge. May we be excused?
Have a very nice day.
Thank you, Judge.
Yeah, can you bring him to the office? Oh, yeah, for your board.